Me, Your Honor, Chad Fears.
Good morning.
Good morning.
Let me start out kind of a roadmap. One, kind of the procedural issues we have with the motion. Second is the 5-star factors. And third is the park line considerations. The first, which was hinted by my colleague, is this is a motion for summary judgment. The plaintiffs, have the burden of proof. They need to come with evidence. Their evidence was a verdict form and hearsay allegations and 2 complaints. When we then, one of the defendants showed, hey, there are some dissimilarities here with Brody. Now plaintiffs say, well, no issue preclusion for Brody, but everyone else. It was their burden to show how they're similar, especially for causation. And they didn't do that. The second issue I have, Your Honor, is their motion comes out in very broad strokes. We want to have issue preclusion on liability causation, and all we have to do is determine damages. Then we get into the reply, and for the first time, we find out, no, it's really 4 issues, which seems a little unfair to all of a sudden spring that on us. So let's go first to the 5-star factors. Before we get that, the cases they cite for issue preclusion in the Nevada Supreme Court really deal with situations that are a shield. Someone's trying to get a second bite at the apple and trying to pursue their claims. Here, they're trying to use it as a sword. And we'll talk about that in the park line factors. But let's go first to the 5-star. First, they've presented no evidence of similarity between the plaintiffs. There's different time periods, different reasons for hospitalizations, different diagnoses, unique diseases, different treatments, different risk factors and medical histories, different environmental exposures. And this is a toxic tort. How much were they exposed during a certain time? They presented no evidence on that. Because we have different consumption patterns, we have different products, retail versus the 5-gallon jug. And we have different dates of purchase and probably consumption habits. Right there, we cannot have issue preclusion on causation at a minimum. And we need to show the injury in fact. They have not shown that. They have not presented the evidence of that other than, I have a verdict, we allege 2 similar things in complaints. That doesn't satisfy Rule 56. And that's what we're here for. Then we go, as we said, the judgment is not final. Still, the time even note an appeal has not even run. That, and that goes to, and if the court were to say, okay, the verdict is final, to me, the verdict is final, I would then argue under Park Line, you should wait until the appeal is done. That is what happened. This is the 4th time I've dealt with this type of motion in district court here in Nevada. The first 2 times were in hormone replacement therapy. Mr. Weatherall, who was the plaintiff's counsel, waited until the ROAT decision was decided, and then the writ for certiorari was denied before he filed his motion for issue preclusion collateral estoppel, both of which were denied by Judge Bixler, and then another judge up in Washoe County that unfortunately I forgot his name. He died when he was on the bench, like 2012. That is the proper course, because if the Gallagher decision is overturned and you base your issue preclusion on Gallagher, that will have to be overturned and we don't save the time. So whether we believe it's final, if you find that it technically is a final judgment, we then under Park Line say the fair and just course is to wait until the appeal has been done. We then go to whether there was an actual litigation on the merits, and as was talked about, there was a sanction against Hannah that liability and causation was determined by the court or put on the court. We do have a 7th Amendment right to a jury determination. That has not occurred. So in that sense, it has not been on the merits.
Walk me back with that last sentence, what you meant by that. You're entitled to a trial on the merits.
We have a jury trial. A jury did not determine liability and causation for Hannah. That's what I'm saying.
You're saying, okay, there we go, okay.
It was a court-imposed sanction. It wasn't a jury-determined fact under the 7th Amendment. That's what I'm saying. So that's why we say it's not on the merits and not actually litigated and been decided. So then let's go to the Parkline factors. Because even if, Your Honor, you find all the 5-star factors are applicable, you still, and that's what Parkline is saying, is we don't want to have to draw a bright line. We want district courts to really focus on this. And in Parkline, it said the list that they listed was not exclusive. And like my colleague, Ms. Lowell said, not everyone applies. But I would say that at least 3 general categories does apply. 1 is the wait and see. 2, the policy behind inconsistent verdicts. And I will agree that there's only been 1 verdict here, with a policy there. And 3rd, the unfairness. And unfairness, and 4th, I'll add 4th one, we're not going to be saving any time based on the missions Mr. Pepperman made. And I'll talk about that last. The first one, the wait and see. One of the issues about the wait and see, Your Honor, is that did the plaintiffs here have an opportunity to join in the judgment in Gallagher? Now, Ms. Lowell explained kind of how the trials were set and how we do have someone over 70 in this Hunwardsen that could get a preferential trial. Plaintiffs' counsel used that mechanism in Gallagher, which they are allowed to do. And I don't want to say that somehow they broke the rules or anything like that. They're allowed to put unrelated people together, put one who's over 70 or 65 in each of their cases, so if they want to move it up in advance, they can. They're allowed to do that. But it would be patently unfair to allow them to use that rule to do that, and then say, now we have to apply in all these cases, because it's kind of the wait and see. The Hunwardsen plaintiffs could have joined in and said, we want a trial with Gallagher. How do we know that? Because the same plaintiffs' attorneys have consolidated Wren and Carrier. And they're trying to get Cava coordinated or consolidated too. That's the whole point of the wait and see. You can't sit there when you had an opportunity to join in, wait to see how that verdict happens, and then say, now, Your Honor, apply it to all my cases, which leads to the second point. One of the Parkline factors was inconsistent verdicts. And again, I will concede, there's not inconsistent verdicts in the sense of another court has had something. But the policy is that with mass torts, it's not applicable. And that was in the footnote 14 in Parkline case. And it cited a treatise talking about there is a train accident. If the defendant wins the first 25 trials, if the 26 they lose, it should apply to the next 25 for the 26 through 50. The policy is there in these mass torts where you have, especially toxic tort, where you have different exposure levels, different consumption levels, you can't have this blanket causation is applied to everybody, or liability is applied to everybody because it deals with different times and different periods. And that was the policy behind the inconsistent verdicts, which we say is a policy, another reason why you should wait here, especially if, well, I'm telling you, we're definitely going to appeal the Gallagher verdict until that has run its course. The third one.
Stop you for a quick second
Yes.
then. When you say you want the appeal to run its course, are you saying the trial should not go forward, or just this motion should not be ruled upon in the manner that plaintiffs are seeking? I just want a clarification because there's no motion to stay before me.
Your Honor, I will tell you, we just barely got on the case. We are not asking for a continuance of the trial. And by my argument, we are not trying to orally move to stay the case. Okay. What we're saying is they shouldn't apply here until these issue preclusions should not be applied until that verdict has run its appellate course. That is what I'm saying.
Okay, or Alcantara. Okay.
The third one is unfairness. And that is, the issue here is, what plaintiffs failed to say is while damages and liability was dictated by the judge as a sanction as to Hannah, the jury was allowed to see punitive damages. And they did not impose punitive damages on Hannah or Milwaukee. Now, Mr. Pepperman just admitted to you earlier that the evidence for Hannah and this warnings have nothing to do with the plaintiffs. So here's the unfairness. if you grant implied preemption or collateral estoppel, preventing us, Hannah and Milwaukee, from raising our defenses, but then allowing another bite at the apple at punitive damages when the evidence is not going to be different, that is patently unfair.
So are you contending that the court should issue preclusion for no punitive damages as to Hannah? Is that what I'm not,
Well, I don't,
flesh out
first
that
of all,
argument?
I don't think I can, because they're going to claim there's not the same party, because these are different plaintiffs. What I'm saying on a park line, that's why you should not impose implied preemption as to Hannah, because we will be at a disadvantage and prejudice, because we already won on punitive damages. And I don't have a mechanism to move this court to say implied preemption, they cannot bring up punitive damages. And so that also goes to my fourth point of saving time. Even if you were to grant these motions, this motion, it will not save time in trial, because they've already admitted Terrible Herbst can litigate all the issues. If they want to get punitive damages against Hannah and Milwaukee, they're going to have to present the same evidence that they would have to present in showing liability and causation. But then my hands are tied behind my back and I can't defend myself on liability and causation. And that's the patently unfairness. And that's why under park line, you should, even if you find the first 4 factors on the 5-star met, under park line, you should exercise discretion and not apply implied preemption here. For the 4 reasons I said: the wait and see, the policy behind inconsistent verdicts, the unfairness if you apply this to Hannah, and especially, but if you even just apply it against Milwaukee, we'll still be brushed with that that finding. And then it's not going to save time, Your Honor. They have to present the same evidence to get to the punitive damages. That's what they're doing. So if the court has any further questions, I'll rest on that.
I do not. Thank you very much. Okay, ETT 1 / Terrible Herbst. Go ahead, please.
Good morning, Your Honor. Thank you very much. Valerie Rojas for Terrible Herbst. Your Honor, I would like to go through first the reason why we opposed the motion, and then followed by why the motion should not be granted. The reason why we filed the motion is because this case involves joint and several liability. And any issue decided against Real Water in this case, especially with respect to retail bottles sold, would be extremely prejudicial to Terrible Herbst and essentially preclude us from offering a defense at trial. And so that's the reason we opposed the motion. And we believe the motion should be denied primarily because under the 5-star factors, the case involving 2019 retail bottles of Real Water sold by Terrible Herbst was not actually or necessarily litigated. And I heard Your Honor ask questions of Real Water earlier, whether they concede hydrazine was in all Real Water. But the evidence...
A little bit differently, counsel, just so we're clear on the record. My question was intentionally phrased differently because I was not requesting that anyone make any concessions in court, but I got the sense of what you're saying. Go ahead, please.
Okay, I apologize if I misspoke on what Your Honor said, but the point is that there is circumstantial evidence that hydrazine was not present in all retail bottles sold, and especially in retail bottles sold by Terrible Herbst. In this particular case, Mr. Hunwardsen is the only plaintiff who contends that he purchased retail bottles of Real Water at Terrible Herbst. And he started doing so in 2016 and continued to do so even after his liver transplant in 2019. But stopped consuming Real Water in 2019. The circumstantial evidence shows that Mr. Hunwardsen drank retail bottles of Real Water for at least 2 years without incident or any problems. The first time he noticed any problem now to real water were in 2018. We believe it's no coincidence that at that time, Mr. Hunwardsen moved to a new home and began purchasing home delivery of real water and consuming it daily. The symptoms he experienced were in the summer of 2018. In the summer of 2019, just before September, is when he began experiencing severe symptoms, eventually leading to his hospitalization in 2019 and his liver transplant in 2019 of September. Those issues were not actually or necessarily litigated at all in the Gallagher trial. There was no retail defendant, either a distributor or a retail store, present to defend the retail bottles, I will say, in the Gallagher trial. So that issue was not actually or necessarily litigated. In addition to the circumstantial evidence I outlined above, there's also evidence that individuals who consume substantial amounts of real water directly from Nevada Beverage, who was a distributor for Terrible Herbs, had no symptoms, as well as people who purchase retail bottles from Terrible.
You're cutting in and out. We're having a little difficulty hearing you.
I'm sorry, Your Honor, is this better?
If you stay closer, we'll try. Go ahead, please.
There is additional circumstantial evidence that hydrazine was not present in all retail bottles. And Terrible Herbs should have the opportunity to litigate those issues. This is similar to the issue addressed by the U.S. Supreme Court in Froh versus Villegas, where the court indicated that even a default judgment should not be entered against a co-defendant while the case is pending against other co-defendants, because ultimately, if we prove at trial that Mr. Hunwardsen did not suffer his injuries as a result of the retail bottles he purchased from Terrible Herbs, and he purchased retail bottles many other places as well, then we should be able to prove that, and that should not be precluded by any ruling that's imposed as in issue preclusion as to real water. And in the event the court is inclined to grant the motion, then Terrible Herbs would request that the jury not be advised at the very least, and that the verdict form simply indicate that they don't need to address that question to avoid any prejudice. And with that, Your Honor, I will submit.
Okay, I've got a question for you. There was a sentence in your brief that talked about bifurcation, but there's no motion before the court, and you can't. There was no counter motions, nowhere in your, even in your title, and on an OST, you would have had to got your own OST. Are you somehow contending that there's a motion to bifurcate on before for the court today?
There was an alternative motion included in the brief, Your Honor.
Wait. Where was it an alternative? How can you do it under the rules? Let's focus on that, right? Because it wasn't even in the caption.
Your Honor, I apologize for that. We're going to withdraw that motion because I think, as I pointed out to Your Honor, the better solution, if the court is inclined to grant this motion, that the prejudice can be avoided by not having the jury informed. And we do have a motion in limine on file with Your Honor. That's motion in limine number 1 that will address that issue.
Okay. I appreciate it. Okay, so everyone who filed something has now had a full opportunity to be heard, correct? Does anyone think that they filed something that they've not yet been heard from? No? Okay. So now let's go back to a brief final word. And the reason why we're going to do a brief final word is, well, you took 3 times as long as everybody. I appreciate you've got the burden, but, right, you were past 30 minutes, right? And we've got to make sure everyone has a full opportunity to be heard, and then what we make it through. Go ahead, please.
Your Honor, I will be brief. I think if we look at this conceptually,
What is the purpose of issue preclusion? It's to prohibit the relitigation of issues that have been fairly litigated and determined. And what we're seeking to apply issue preclusion on are the narrow issues that were fairly litigated to the Gallagher court and to the Gallagher jury and determined. The entire policy behind issue preclusion is to say, look, once something's litigated and decided, it's decided. We don't need to spend time, money, judicial resources relitigating all the same stuff. The only thing that's going to do is it's going to create it risks creating the potential for inconsistent verdicts, which is unfair. There's no reason why real water should have hydrazine in it for the Gallagher plaintiffs, but not for any of the other plaintiffs.
Can I stop you for a second and ask terrible Herbst argument? Bless you, right? With regards to 2016 to 2018, multiple retailers versus the direct home delivery. How do you address that with the hydrazine concept?
Well, what you heard with terrible Herbst was a bunch of, well, look at all this time frame, it's different. But what the evidence that actually was litigated and part of more than 100 pretrial motions, and which ultimately led to the stipulation, was that real water was producing hydrazine in the E2 concentrate by the electrolysis process. They followed that same electrolysis process from
what year to what year?
From when they started making water in 2008 till the time they stopped producing water in 2020. The entire time they followed the same exact process, the same exact
location,
recipe.
Both retail bottles and delivery. Is that what you're contending?
Well, this is what the facts and the evidence are. Is that
was that actually litigated in Gallagher?
It was
because you
all,
had no distributors and no retailers.
Yes, it was all litigated in Gallagher. The reason that there was no distributor in the trial was because this was all litigated through more than 100 pretrial motions, and it was obvious. Real water conceded there's hydrazine in all this water. It's in the retail water. They tested the retail water to try to prove, oh, it's only the 5 gallon. It's not the retail water. They found hydrazine in all the retail water. That's what the evidence was. It prompted.
You're telling me there was terrible Herbst water tested in Gallagher?
It was Whole Foods water.
My question was very specific. Are you telling me there was terrible Herbst water tested in Gallagher?
Terrible Herbst water was not tested. It was the retail water. But it was the concentrate. That's where this water, the hydrazine, was being produced. They used the same exact concentrate to make every drop of water. The retail water, the 5 gallon water, the water sold at Whole Foods, the water sold at Terrible Herbst, the water sold at Sprouts. Every ounce of that water was made from the exact same E2 concentrate that was made by almost exclusively by the same exact person, Blaine Jones. And that is what was all litigated. It was determined that hydrazine was in all the water.
But how can you say that if nothing was ever tested? Remember, Gallagher was not my case. You all keep mentioning it, right? Was Terrible Herbst in Gallagher? And if so, to what? Through trial?
No, Terrible Herbst was not a party in Gallagher.
At all, right?
Right.
That's what I understanding was from their briefing.
And that is exactly why we're not seeking summary judgment against Terrible Herbst.
But aren't you de facto, is what Terrible Herbst's argument is, if you're de facto saying that the water product which they sold had hydrazine in it, aren't they de facto losing part of their opportunity to litigate their defenses, and they did not participate in Gallagher? Isn't that what Terrible Herbst is contending through counsel and through the briefing?
No.
That's not what they're contending?
Well, that's what they're, asserting as a blanket assertion. But what the fact is that there was hydrazine in the water that was put in there by the manufacturer. That was what they were doing. That's what they conceded. That's what was litigated in Gallagher. That's what we seek issue preclusion on. Terrible Herbst, they're a distributor. They sell the product. They have no evidence or information about how that gets in, the hydrazine
retailer?
got in there. Terrible Herbst is a retailer.
You said distributor. I'm
I'm
sorry.
sorry.
I'm just trying to make sure we're clear. Okay, go ahead.
So if a product is defective, every person in that chain of distribution is strictly liable for the harm caused by that defect. Okay, so what the issue preclusion relates to is what was litigated was the fact that there was hydrazine in the water.
Are you saying it was litigated that there was hydrazine from 2016 to 2018 that ended up in retailer Terrible Herbst for their purposes of sale?
I'm saying
What have you presented to this court in your briefs that would apply to Mr. Hunwardsen, who's articulated to be the one person who bought at retail location Terrible Herbst? What evidence you presented this court for issue preclusion?
the evidence for issue preclusion is what pertains to the hydrazine being in all real water. It's in all the real water. It was in all the E2 concentrate that was tested by the FDA. It's in everything.
What years?
The FDA didn't do their investigation until 2021.
Right, that's why I'm asking this question, right? It's because Terrible Herbst is articulating that things were different from 2016 to 2018. They were contending, it's just in their briefs, right?
Yeah.
And in the oral argument, that that he did not get ill, right, from 2016 to sometime in 2018. And so based on his dates of purchase from them, there hasn't been any evidence presented that there was hydrazine in what they sold. I'm just asking, what are you saying was actually litigated that would dispute that, right? Because you have the burden to establish to the court. So I'm just trying to get a better understanding of how you're tying it into that unique, not the general concept of a stipulation from Real Water Affinity Lifestyles, not to be confused with Real Water Tennessee, as other counsel have articulated.
The issue was litigated in Gallagher whether there was hydrazine in both the 5-gallon product and the retail product in 2019. One of the plaintiffs, Keith Haley, he exclusively drank retail bottles, and it was determined that those bottles that he consumed were defective due to hydrazine contamination.
If you go back to 2016 to 2018, which is the time period that Terrible Herbst is articulating?
The issue of whether hydrazine was in the 5-gallon and retail product in 2018 was litigated in Gallagher. Mr. Belsky drank 5-gallon and retail bottle water. He was ill in May of 2018. It was determined and admitted by Real Water, the manufacturer of the product, that hydrazine was in its retail and 5-gallon product in 2018 at the time that Mr. Belsky became sick.
How about 2016?
2016.
Was that litigated in Gallagher or 2017?
Those timeframes weren't at issue in Gallagher, but the evidence that was litigated in Gallagher was that the hydrazine was being produced as part of the electrolysis process when making the E2 concentrate, which was used to make all real water at all times from the beginning to the end. There was evidence introduced in Gallagher as part of the punitive damages claim that showed there was red flags that hydrazine was in the bottled water going back to 2014. Customer complaints related to chemical smells, being violently ill. In 2018, we presented testimony of Steve Watkins, who was hospitalized with liver failure. And his wife emailed Real Water and said, my husband's in the hospital with liver failure. His doctor said, stop drinking the Real Water. The evidence in Gallagher was that hydrazine at high enough concentrations has an ammonia-like or a fishy-like smell. We introduced evidence of customer complaints in 2017 from a retail bottle purchase that the water had a fishy smell. So there was evidence of hydrazine from the beginning of production all the way through to the end of production in the 5-gallon and in the retail bottle. But what Terrible Herbst is arguing is, oh, there's different times, they don't have any argument or facts that hydrazine wasn't in any of the water. What they do have arguments, they do have a potential defense relates to the amount of hydrazine. They can say that there wasn't enough hydrazine in real water. And that's what their experts say. They can say all they want to in court how there's no evidence of hydrazine in the retail bottle. Not even their own experts suggest that. They acknowledge, based on the retail bottle testing and all the other evidence that was presented in Gallagher, they can't say that there's not evidence of hydrazine in the retail bottles that Terrible Herbst sold. Instead, what their defense is okay, well, there were small amounts of hydrazine. We concede that, but it wasn't enough to cause the injury or to be a factor in Myles Hunwardsen's injury. And that defense, they can make that defense. This ruling, what we're asking, doesn't apply to Terrible Herbst. It doesn't affect their defense on the usage amount, and it's no different than any other. Like in Gallagher, if Real Water, the manufacturer, chooses to concede, hey, our product was defective, that doesn't mean that they can't argue causation, and it doesn't mean that they're prejudiced by that finding. It actually is beneficial to them because as a retailer of the product that is defective, that the manufacturer is admitting and acknowledging is defective, they have rights, they have remedies. It's not to prevent the application of summary judgment or issue preclusion where it's clearly applicable and should be applied. It's to go after the manufacturer for providing them with a defective product. They can sue for contribution, they can sue for indemnity. So if their defense that they're allowed to maintain and present at trial regarding the usage amount, the dosage, if it doesn't come to fruition, then they have the remedies against Real Water. So it actually benefits them. They're not in any prejudiced state. It actually helps them in the long run of what their actual legal remedies are. So these, like I said, these issues were litigated, they were decided, and it's not prejudicial to Terrible Herbst to maintain all the same arguments and defenses that they would have had before this motion and after it. It won't affect the before and after analysis of the motion. Just a couple other quick points to address. With respect to Milwaukee, because I do think this is an important issue with what you heard. In their motion, they concede that issue preclusion is appropriate as to this warning adequacy and warning causation. So on page 26, line 28 through 27, page 1. Plaintiffs are most likely to succeed regarding their first request as to number 2 on the verdict form, the determination by the jury that the MW500 ORT meter did not have an adequate warning that would have been acted upon. They conceded. The argument only is that, oh, well, yeah, that's true, you should apply issue preclusion, but the jury misread these instructions and inferred something. That's not the law. The law is that the jury is instructed, they're presumed to follow the instructions. Milwaukee concedes that the jury was properly instructed. She admitted it. She stood here and said, I admit that they were instructed, but we don't think they followed those instructions. You should find that they didn't follow them. That's contrary to the law. And unless Your Honor has any other questions.
I do have one question. The finality issue raised by multiple of the other parties saying that this should not come in.
So,
Mr. Kemp, you may not realize that those speakers are very good. So when you're speaking with Mr. Parker, A, I can hear it whether you want me to hear it or not, but B,
Your Honor.
It's hard when I have multiple people, so push down the little thing if you're gonna speak, right? Appreciate it, thanks. So just everyone, why don't we take a 10-minute break, because by the time you all leave and come back, so let's come back at 11:15. Thank you so much. Okay, we're back on the record. Hope everyone had a very nice break. Right before the break, the court had asked the question to counsel for plaintiff in response to the statements made by various of the other parties with respect to the finality.
Yes, Your Honor, thank you. The argument with respect to the finality is you cannot apply issue preclusion to a judgment unless it's been subject and affirmed on appeal. And I believe this was a primary argument from defendant Hannah Instruments, and the citation given to the court was, well, I was in the pharmaceutical case, and Peter Weatherall, he didn't try to apply issue preclusion until after the appellate decision came down. Well, that may be what Mr. Weatherall decided to do in that case for one reason or another, but that's not legal authority that says you can't apply issue preclusion on a final judgment based on a jury's verdict on issues that were fully litigated and determined by a jury, unless that jury verdict has been appealed. And in fact, they don't cite any law for that proposition, because that's not the proposition, that's not the law at all. What the law is that it's sufficiently firm to give it preclusive effect. And there's no dispute that a jury decision resolving the entirety of the claims, resolving all the issues that we seek to apply issue preclusion, is conclusive and sufficiently firm to apply issue preclusion under the law. In fact, we cite in our reply a number of instances where orders or judgments far less conclusive and firm as a jury verdict has been given issue preclusive effect. And there's really a practical reason for it if you think about it. Okay, we have a jury verdict. The issues were tried. They were raised. They were litigated. They were tried. They were determined. You have a jury determination, and you get an appeal. Okay, we don't know what's going to happen on the appeal. We haven't seen any of the arguments. We haven't been able to evaluate any of the merits of the appeal. But ultimately, it doesn't matter, because if you apply issue preclusion on it and something happens on appeal, there are potential consequences. If you don't apply issue preclusion and we just go forward on the same claims and retry the same things, over and over again, then you're still going to have the consequences of an appeal. We don't know what those are going to be. They're hypothetical. They're speculative. It's not a basis in the law to make a determination on issue preclusion. What is a basis is the fact that we have a jury verdict on issues that were actually litigated that is memorialized in a final judgment, and the law says that is more than enough to be considered final on the merits to give preclusive effect. One more thing on the retail bottle issue, because I feel like in our briefs, in the briefing and the reply, it very clearly states these are the narrow issues in which we seek issue preclusion, and these are the reasons why issue preclusion applies. I think the arguments in opposition, particularly with this retail bottle kind of unidentified defense, is they're throwing a lot of things out there that aren't supported by any evidence or any basis to give them any credence. And I think that has a dangerous effect of creating confusion so that issues are decided on, oh, well, what if this, what if that, when none of those what ifs are actually valid. You've heard repeatedly, oh, well, there's circumstantial evidence that hydrazine is not present in all the retail bottles sold. But none of that so-called circumstantial evidence has been identified. None of it exists in the underlying expert reports or is supported by any of the expert evidence that has been disclosed in this particular case. And I think it is incumbent on these defendants, if they're going to throw something out there to say, Judge, you're taking away this defense or this issue precludes the application of issue preclusion, they should identify what that is. Because if they are forced to do that, I think it would become very clear to the court that those are just broad, sweeping, conclusory assertions that are not supported by any facts or evidence in this case. And, I think it's a lot of my fault because, when I lived with this case for years and, know it so well, sometimes I assume that.
I appreciate, but come on, final brief response.
I understand.
I
Your Honor.
appreciate it. I mean, in fairness to everybody else, we need to also get through, right?
Let me close with this.
Thank you.
Very simply, the real water manufacturing process involved making the E2 concentrate, which was a proprietary concentrate, in a separate room by one person, Blaine Jones, made it. Proprietary process. They did this by electrolyzing a chemical mix of water. And they were creating hydrazine in this process that was made in this E2 concentrate. Then once they would make the E2 concentrate, they would store it. And they would take that E2 concentrate and they would use it to make the finished product. They would dump it into purified water to make the finished product. And this E2 concentrate that was made in Las Vegas, whether it was at Henderson, whether it was at the Desert Inn facility before that, wherever it was always made in Las Vegas by Blaine Jones from the start of the outset. And the same E2 concentrate that was made by Blaine Jones was used to make every bottle of water, real water, that was sold. The E2 concentrate was shipped across the country to places like Real Water of Tennessee to make the real water there. It was sent to the different facilities, anywhere that they made it. It was used on a 5-gallon product. It was used on the line at the same facility to make the retail product. Once that product was made with the same E2 concentrate, it was sent out through distributors to various stores, Whole Foods, Terrible Herbst, Sprouts, numerous other retail stores, and it was sold. But it was all made from the same E2 concentrate that had the hydrazine. And this was an issue in the Gallagher trial, and I'll just end with this. On page 5 of our reply, I list several excerpts from the trial transcript. Okay? This is Real Water's counsel to the jury. And Mr. Marlowe had never heard of hydrazine at all. Mr. Marlowe's the Real Water inventor who licensed it to the company. And Mr. Marlowe had never heard of hydrazine at all. And what happened was not intended, but it made these people sick. Hydrazine was formed, and you'll hear from the experts, when they electrolyzed the water, and it was found by the FDA after people got sick. That's what he's talking about. This is opening statement.
Argument of counsel, not evidence.
Real Water's counsel saying this is what the evidence will show. Hydrazine was formed in the electrolysis process when they're making the E2 concentrate. It was found by the FDA. It was tested in every sample that the FDA tested for hydrazine. They found hydrazine in the E2 concentrate used to make all the water. And one other excerpt. I expect that other parties may try to put words in our mouth. They don't need to do that. We'll tell you what happened. We'll tell you we screwed up. There was hydrazine in the water, okay? And that's all we're asking, Your Honor, on this issue, is based on their own statements, based on this evidence at trial, based on all the experts' testimony that's before you, is to apply issue preclusion to say, hey, we're not going to relitigate the issue of whether there was hydrazine in the water. It was admitted. It was litigated. It was determined. Hydrazine was in the water. That is not unfairly prejudicial to terrible Herbst. They do not have any legitimate basis to come in and say that hydrazine wasn't in the water. So for those reasons, Your Honor, we'd ask that you grant the motion with the exception of Ms. Brody as to the issue of causation, grant the rest as requested.
Okay, appreciate it. Thank you very much. Thank you for the extensive briefing, the extensive oral argument for the last 2+ hours, approximately. And, well, all parties agree. The determining aspects is the court has to look at issue preclusion because it's a motion for partial summary judgment based on issue preclusion. And as stated by the Alcantara versus Walmart stores case, 130 Nevada 252, 2014, a corollary claim preclusion, issue preclusion is applied to conserve judicial resources, maintain consistency, and avoid harassment or oppression of the adverse party. That usually is, that case actually was in the defensive aspect, not in here where it's being asked to preclude things that were tried by the party who actually tried some of them, but not all of them. So there's factors that the court needs to evaluate in order to ascertain whether issue preclusion is available. The following 4 elements are required. 1, the issue decided in the prior litigation must be identical to the issue presented in the current action. 2, the initial ruling must have been on the merits and have become final. 3, the party against whom the judgment is asserted must have been a party in privity with a party to the prior litigation. And 4, the issue is actually and necessarily litigated. And that's Alcantara, which is citing or quoting directly from 5-Star Capital Court versus Ruby, 124 Nevada, 1048, 2008. And as all parties concur, the party seeking to apply issue preclusion has the burden of proving it should apply. Bauer versus Harris, Laughlin, 125 Nevada, 470, 2009. So now you have to go through these factors with regards to each of the aspects of issue preclusion that's being sought by this court. Well, with regards to, I'm going to break it down the way it was really argued by plaintiff. The first one was regard to issue preclusion with respect to real water in the defendant capacity. I'm going to carve out real water Tennessee for just a quick second, but in that, so in the defendant position, the first aspect was asking for issue preclusion with regards to liability. So the court applying the 5-star factors, and of course the court also has to look at Park Lane, which was cited by all the parties. That's Park Lane Hosiery versus Shore, 439 U.S. 322, 1979. So walking through those factors. First, with liability. Well, it's conceded with regards to real water in the defendant position that it was the party against whom the judgment is asserted in the fact that it was the same party, but there's a dispute as to whether or not it is a judgment because that ties into the stipulation between the parties and whether or not that was, quote, on the merits and separate apart final, but also was actually and necessarily litigated. Well, realistically, counsel, despite all the excellent arguments, it is plaintiff's burden, and this court has clear aspects that are straight out of 5-star and straight out of Alcantara, which says that all those factors must be there. This court can't modify it and say, well, even though the specific Supreme Court case law says the issue was actually and necessarily litigated, that somehow a stipulation would fall into that category. So that factor has not been met. In the absence of that factor, that would mean that the court cannot grant the issue preclusion motion for partial summary judgment with regards to the liability factor with regards to real water. In addition, another factor that is missing is that it was final. Now, the final factor, you all argued a little bit whether or not it's final. It's been argued 2 different aspects about whether or not the total judgment is final or whether or not there's still outstanding aspects in light of the procedural history of Gallagher. But independent, that really has been subject to argument mostly between Milwaukee and plaintiffs, but even taking not taking, that into account, the fact that it was not actually necessarily litigated. Also, what you have is the issue decided in prior litigation must be identical to the issues presented in the current litigation. While I appreciate that the focus has been by counsels for plaintiff that the issue for liability is the hydrazine, realistically, what has happened here is this court doesn't have presented to it from an evidentiary standpoint, in order to have, under Rule 56, the issue preclusion that's being requested in the motion for partial summary judgment, that the prior litigation was the issues were identical. You all have distinguished, has been raised in a variety of the different briefs, that the issues, different ages of the parties, different years, the amount they drank, whether it was the 5-gallon, where they purchased it, how they received it, how much they did, whether they were hospitalized or not, that each of whether there was specific comorbidities, right? And that brings into all of those factors. So realistically, and the amount of hydrazine, whether the hydrazine, right, I can't focus it on specifically hydrazine being in the water, because what you all have articulated is that in the Gallagher case, the fact that it was the amounts of hydrazine that was in the water with regards to those particular plaintiffs was the stipulation. So what the court doesn't have before it in this case is actually the fact that hydrazine was in the water. Maybe it was in such minimal parts as potentially argued by ETT1 DBA Terrible Herbst, that it didn't have any impact, or that it had to have a certain level of hydrazine. So the court can't find liability for issue preclusion. And remember, this court's only looking at this as a standard of issue preclusion. I'm not making any rulings on any basis other than for the issue preclusion components. And so then that would be with regards to 5-star. When you follow it along with Park Lane factors, it wouldn't be fair, and from both a policy standpoint, this was articulated by Real Water, that if they made a choice with regards to certain plaintiffs, and maybe being the first certain case, to make a determination that they're going to accept liability, it wouldn't be fair under Park Lane to say, well, that means somehow they've done it for every other case, particularly because you have a procedural posture here. Here you have approximately 20 cases. I know some have been consolidated since then, but at the outset there was over 14 cases, and then some others came in, and they're all in different postures. And it was specifically decided to only seek coordination of discovery. It was decided not to do it as a class action. It's decided not to do it as consolidated matters. In this case, where I'm looking at only for this case, nothing was consolidated in this case with these claims of these plaintiffs with regards to Gallagher. And so it'd be unfair that if an evaluation was made to stipulate for certain reasons, for certain factors in one case, that would be applied across the board to another case that has different plaintiffs with different comorbidities, different factors, etc., because realistically, potentially could discourage resolution between parties, stipulations, etc. So I don't find that the Park Lane factors have been met as well, and I appreciate many of those can be discretionary, and it's not an exhaustive list, but there's factors within Park Lane that have not been met as well. So then you go to Real Water as a defendant for the causation standpoint. Similarly, plaintiff has not met their burden there because while they've modified the request in open court to now exclude Brody, even with the 4 others, there's not a specific analysis how specifically for each of those that it shows that there was causation for those 4 individuals that can be tied under 5-star that were actually litigated in Gallagher. Okay, well, remember, I'm not making any merits decisions. I'm doing purely issue preclusion, folks. Okay, because the issue decided, well, I don't know all the comorbidities of all the Gallagher plaintiffs because some of those issues didn't even have to come to light because of the stipulation. So don't even know actually if the prior litigation had the identical issues, identical comorbidities. I appreciate you all the distinction in your various charts as far as similarity of hospitalization dates, right? But the comorbidity, the age factors, the amount they drank, whether it was the 5 gallons, whether it was the retail product, how much they did during what time period, etc. Don't necessarily know it from a causation standpoint. Also, you have the initial ruling on the merits and tied to the concept of being an actual judgment. Well, here you have a stipulation, and so you don't have those. Were not all flushed out. The other 5-star factors have not been met, and that also applies to the issues actually necessarily litigated. As far as being the same party, you've got real water and DBA affinities, obviously when I'm talking about this juncture, and so you have that same party, but the other factors aren't. If you look to then the Parkland analysis, which realistically you've got the same unfairness aspect with regards to that. As far as the wait and see that's been argued, I can't say one way or another realistically with that one, because you all did do a motion for preferential setting, but remember, you might recall for those of you who were here at the time, is that it wasn't truly under the rule. It was a modified. It was like, can we get an expedited trial? It wasn't a preferential, because nobody wanted it within that specific time which the mandatory language had. Please see this court's order on that, and that was the reason, okay? So whether or not there could have been a preferential in a different department, realistically, the court, you all are excellent attorneys. What you chose to strategize, I can't say whether it's wait and see or not. I really focus on the unfairness factor with regards to Parkland. So that addresses utilizing those factors. So then we go to, I'm breaking out the 2 meter defendants because I find that's more appropriate realistically. So I'm going to go first to Hannah. So Hannah, it's the failure to warn. Well, there I take no position on the merits of the sanction. I take no position on the merits of the underlying aspect. But what I have to look at again is applying 5-star. When I apply 5-star, I can't say that it was actually necessarily litigated, a sanction, because regarding it here, it's been asserted to this court that the sanction was not disclosing that the testing with the meters, and that was very case specific. So whether it's being litigated here or not, and what the outcome of that and what it may be provided to the jury could be very, very different. There's just not enough evidence presented to this court that this court can rule under a Rule 56 standard that somehow there would be liability under the claims asserted against Hannah, whether the warning was adequate, because it wasn't necessarily litigated. So realistically there, ties into your judgment. The finality issue you have as well, but realistically those are all independently, because the finality aspect only goes to what has been presented to this court, that there still may be some of the claims that weren't actually on the verdict form, was argued by Ms. Lowell with regards to Milwaukee, and I don't have it one way or another. Clearly, you all, good news was you didn't give me all the trial transcripts from the entire trial. You know what I mean, to highlight something. Well, many of you did give briefs that were in excess of the EDCR, and I'm sure that's going to get rectified for the next time. But in looking at what the court really has from evidence, I can't make an assumption one way or another, and I would have to do so in order to rule in favor of plaintiffs. I can't make assumptions. I don't make assumptions. I won't make assumptions. So therefore, I have to deny it with regards to the warning that actually been acted upon here. Once again, you've got so many different individual plaintiffs. You don't know what they would. I don't have what is it the same? Would they not have done it? What was the aspect? In the absence of having the first, I really can't rule on the second, and so therefore the court would have to deny it under 5-star. And then, of course, you go into Park Lane. You have the prejudicial aspect, the unfairness, because here it's being offered in an offensive aspect, and I mean offensive, and that not offensive, right? Offensive. An offensive aspect is the issue preclusion that's being sought, is that, well, since they got sanctioned in one case and it didn't get fully brought in front of a jury, that, Your Honor, in this case, you should just view it as that it wasn't adequate, and therefore they wouldn't have, if the warning would have been acted upon or not, should really never go to the jury as well. And the court can't, because I'd have to make assumptions that are not before me, because of not being litigated. So it would be unfair to make those assumptions, because realistically it would be putting a party in a situation where they're going to be held accountable in one case for actions that they did in a different case. We'll hope nobody's going to be doing sanctionable conduct in this case, but stay tuned. If I have motions before me, I'll address them when I get the motions, but they're not before me at this juncture, so I can't take a sanctionable conduct and assume it's going to happen here and then do a negative aspect to that party. So now we go to Milwaukee. Well, Milwaukee, part of what I just said would equally apply. Now here, the distinction was there was a jury verdict, and the court can't make an assumption whether the jury did or did not obey everything. I'm not the trial judge. That's next door. If you have issues on that, it either goes next door, I used to say upstairs, don't have to say down the street. That's not before this department. This case is only this department, not any other case, with regards to what I'm ruling on today. So I don't make any assumptions there. But what I have to look at is what is actually been presented. So here, this court doesn't have the benefit of all of this specific information to know if the issues are going to be identical as presented in the prior action. With regards to, say, Ms. Brody, did it have an impact on certain people due to their age, comorbidities versus other people, versus Hunwardsen, okay? So you have all those factors, and then here you also have, well, independent, you have the issue about whether it's final or not final. It was asserted by Milwaukee that the plaintiff is still in, that the jury verdict form did not include certain claims. Now, whether that's accurate or not accurate, it really hasn't been presented to the court, so I'm not taking it one way or another, but realistically, I have an issue in general about it becoming final because I don't even know if post-trial motions are done and everything's taken care of there, even at the district court level. I don't even know your timing on reconsiderations, etc. So that would be with regards to the warnings. You also, there was not issue preclusion. Then, you also had the distinction with regards to Milwaukee instruments on the nature of the actual cause of action asserted in Gallagher versus asserted here. By the plain language of the two complaints, while we are both due, we are notice pleading, this court can't make an assumption that what was intended as having sufficient notice in a complaint that did not have the specific cause of action means it was the exact same cause of action, whether it's UCC or some other based here in this court. It just hasn't really been presented to this court that I have that information, so I can't make an assumption one way or another. So then we go to the breach of implied warranty. This one's a bit more challenging. Because when I look at the liability aspect with regards to the breach of implied warranty and whether it was fit for a particular purpose, that portion I'm inclined to grant the motion for partial summary judgment for issue preclusion. And here's the reason why. Is because that was fully done at the summary judgment level. It wasn't an issue that would have been presented at the time of trial that could be potentially impacted or not impacted by Hannah, and by the sanction with regards to Hannah. Am I inaccurate, counsel? Ms. Lowell, you're standing up.
Yes, at the end of this, I believe there might be some confusion, as the breach of implied warranty was the claim that was not included in the pleading. And I'm just confused as to what you just said. I'm sorry, so sorry.
Yeah, no worries. Breach of implied, but the breach of implied warranty was being sought for issue preclusion by plaintiffs in this case. Part of the aspect that was argued to this court in this case with regards to the breach of implied warranty is that it was already determined on summary judgment whether it was fit for that particular purpose. Is that correct or incorrect, counsels for plaintiff?
You're correct, Your Honor.
Okay. So that's the part this court was ruling on. I'm just going in order of how their argument went. I figured it was, you all argued it from each of your perspectives, but it made most sense to go that. And yes, I'll get back to Real Water of Tennessee. I know I've gone to the meter defendants, but since you raised the third party, I'm going back there in a moment. Okay, so whether it was, however, the court's inclined not to do, whether it was a substantial factor, because that substantial factor component, for a lot of the reasons that the court just said, I don't think it meets the 5-star aspects, because those would be individual specific, okay? Whether it was a substantial, and that would be from a factual standpoint. So then you go to ETT1, terrible Herbst. The question whether or not this motion really addressed them or not was moot for Costco. Moot for Whole Foods, my apologies. And so don't have to address that aspect. Well, for terrible Herbst, kind of hard to grant or deny when plaintiffs tell me it doesn't apply to them, but I really think in light of the court's prior ruling with regards to denying the issue preclusion on the liability portion for Real Water, I think I pretty much have mooted any aspect with regards to terrible Herbst. So I don't think I need to rule on it, but if either side is asking me to rule to give an independent determination, I mean, I don't see something that's still out there, but counsels for plaintiff, do you still think that there's, and I'm going to ask terrible Herbst something as well. Do you think there's still some aspect of your issue preclusion that's before the court for terrible Herbst?
Not as terrible Herbst.
Okay, thank you. Terrible Herbst, do you still think that there's something out there in light of the court's analysis thus far?
No, Your Honor.
Okay, so nobody thinks there's anything out there for me to rule on. I don't need to rule on things. I don't give advisory opinions. Okay, so that should have taken care of every aspect. I think I'm going to have a question on Milwaukee that you all may be asking me, but let's go back. So counsels for plaintiff, do you have any questions for the court at all?
Your Honor, you're granting the breach of implied warranty as to Milwaukee.
As to fit for a particular purpose, but denying it without prejudice with regards to is a substantial factor for the reasons the court stated under 5.
And the failure to warn you're denying. Didn't you mention the failure to warn, Your Honor?
The failure to warn, I denied without prejudice for all the reasons stated. I denied it both as to Hannah as well as to Milwaukee,
Thank you.
with the analysis being a little bit different because of the various factual and procedural aspects. And realistically, it's straight out of 5-star. I mean, I hear the arguments, I hear the analysis. 5-star doesn't have any carve-outs or exceptions. So, I know Alcantara has analyzed 5-star, and so have several other cases, and they've come with those same criteria. So, counsels for plaintiff, I think I've taken care of you. Is there, Hannah's about to step up, so is Milwaukee. So who's going first on your question?
Chad Fears on behalf of Hannah.
Nobody in front of it.
Just right in front of you? Okay.
Yeah.
Red's good, green bad?
Yeah.
Oh, okay. Your Honor, what is the finding that you're making as to that it's unfit for a particular purpose for
It's not your client, counsel. Do you represent Milwaukee?
No, but we sell the product to Milwaukee.
You sell the product to Milwaukee, right, because you're part of the SID
Yes.
groupings, right? But shouldn't I be answering that question on behalf of Milwaukee, right? Because how would you have standing to ask this court this question with the specific way that this is procedurally done in this case? If you're saying that you're the same, there should be piercing of a corporate
We're
veil.
not, no.
Then you might want to have Ms. Lowell ask me that question. I don't know.
Well, I'll let Ms. Lowell ask that question what the actual finding is.
Yes, Your Honor. Elizabeth Lowell on behalf of Milwaukee Instruments. My question is, here we have a claim for breach of implied warranty under NRS 104.2315.
Right. You made a distinction between that versus it not being specifically articulated in the underlying Gallagher complaint. The court is aware of that.
Right. So your finding is based, the jury found the meter was not fit for the particular purpose of making alkaline water. Is that the finding? And how would that impact what is left on the claim that is before this court, which my point was there are more elements in order to find liability on a claim for breach of implied warranty. There are additional elements that were not in the jury instructions. So is there a finding on liability, or is it a factual finding, or is it based on the summary judgment finding that Judge Williams issued in the order granting summary judgment? That is my question.
We've now just bundled it very differently. Mr. Parker, were you?
Your Honor, I thought you hit the nail on the head because your comments in terms of granting that part of the motion almost read verbatim from the jury and verdict form.
Yes.
Question number 4 on page 2, which is an exhibit to our motion. I would have thought that I'm sorry, I can't recall counsel's last name.
Lowell.
Lowell, I apologize, Ms. Lowell. would have also understood that the jury instructions that preceded the verdict form had all of the instructions that she was just alluding to. So the jury instructions had everything. There was no alternative instructions suggested by Ms. Lowell at the time. And the verdict form is exactly what the court just read, which of course is a decision on the merits.
Where the court
Absolutely, Your Honor.
was going, because it's presented to this court, it was attached as being fully litigated, it went before the jury, it went through the issues, any assertions as to whether or not certain aspects of it should or should not have gone to the jury. It did go to the jury. It was fully litigated. It had the full opportunity to be presented claims and defense same parties. Its verdict form has been entered. In this regard, it was not asserted that this was something that still had some outstanding aspects. Now, whether it's subject to appeal or not, under that scenario, realistically, if you held up cases for appeals for years, I mean, you wouldn't get any cases done, okay? So it wasn't the appeal purpose. So I guess I'm not clear. I was going straight from their exhibit and straight from the verdict form, right? And the jury instruction in the verdict form. So I guess I'm a little unclear what you're asking the court.
I apologize for not being,
Well, there's no apologies necessary. I'm trying to make sure I'm hearing your question
so
and understanding what you're asking the court.
Plaintiff's exhibit, number 3.
Okay, hold
are
on
the
a second.
jury instructions.
I can either try and go grab it out of a binder, or I can go back to the actual pleading. So let's make sure we're on the same page. And you do realize, folks, we're going to have to break for lunch and come back to do your jury questionnaire, which I have to get out to people. Right? We have to get out to your people. So why don't we put? So what are you asking the court to go back to, please?
Plaintiff's exhibit number 3.
Okay, hold on just 1 second. You know, when you have it handy, I have to go looking through everything. Just give me just 1 moment.
I have it, Your Honor. I don't have it written on it. I can give you mine.
Do you mind if counsel just quickly gives it
Sure.
to me so that I can,
I mean, I have it also.
whichever side, you both can give it to me. Whoever wants to give it to me, it's fine. I just didn't know if you were going to ask your question based on that.
Number 34.
Okay. Okay, go ahead. So your question was what?
Does not articulate correctly the elements of a claim under NRS 104-2315.
Okay.
And that was in our, and we did submit jury instructions. They are at our opposition exhibit L, which has attached to it L1, L2, and L3. I believe in L3.
Okay. Do you have the verdict form? Is it attached here quickly as well?
The verdict form is attached to plaintiffs.
No, I know it's in plaintiffs. I just didn't know if is it in your grouping. Real quickly, you've got your own little grouping here.
There's no verdict form in exhibit L.
So we're clear. Looking at jury instruction number 33, right? Jury instruction 33. Plaintiffs also assert that claims against Milwaukee for breach of the implied warranty of fitness for a particular purpose.
Right.
Okay. The court has found one of the particular purposes of the MW50 ORP meter was to take negative ORP readings while making alkaline water. This is a binding determination. Okay. The court's finding that part, right? Okay. Binding. In order to establish their claims for breach of implied warranty of fitness for a particular purpose, the plaintiffs must prove the following remaining elements by a preponderance of the evidence, right? And then there's the two remaining elements. That the MW500 ORP meter was not fit for the particular purpose of taking negative ORP readings while making alkaline water, okay? And then the second one is that the breach caused damage, okay? So what the court's also finding is just like the jury found, right, which is in the verdict form, that one has been met. that the MW 500 ORP meter was not fit for the particular purpose of taking negative ORP readings while making alkaline water. That would be a legal determination made, right? It's the same meter that's being asserted in this case. It's the same process that was being done that's being in this case. That was actually litigated, actually came out on a verdict form. Well, I appreciate that you may feel that there are some inconsistent instructions in Gallagher. This department takes no position on that because it's not before me. The legal standard of what actually happened with the determination of the jury of that prong, the court is finding is issue preclusion in this case, but not the damages component. That's what the court's ruling is. Now, appreciate people might have different views on that, but that happens every day with every ruling, right?
Can I just articulate, if you look at NRS 104-2315, which is the claim that they are making here, that includes additional elements to what you have just read. And those additional elements are in, were proposed as a jury instruction. I mean, NRS 104, I'll try and remember the exact language. It says, seller must be aware at the time of contracting that the meter is being used for a particular purpose, which I think is in there. But it also says, and seller must understand that the buyer is relying on the seller's skill and judgment to furnish appropriate equipment.
I'm hearing what you're saying, but I think what you're saying is outside of the scope of what is being presented to this court for issue preclusion. I take no position on whether or not you're saying that the instruction should have been different for the jury. That's next door. That's not this department. I'm ruling for issue preclusion based on what was actually presented in Gallagher under the standards of 5-star, fully taking into account, and Alcantara, fully taking into account Park Lane in making the court's ruling on what should be issue preclusion, in this case, Hunwardsen, okay? Whether you feel that maybe the claims were different, maybe there should have been additional prongs proposed, that's not before me today. Counsels for plaintiff did not seek to add additional elements. You may disagree with the court's ruling, but I do need to move on because the court made its ruling based on what was presented to this court in this case, based on the standards of 5-star and the standards of Park Lane, okay?
I'm just confused as to whether in this case we can argue that the buyer was not relying on the seller as articulated in the statute that they're bringing their claim under.
That would be an advisory opinion that's not presented to this court at this juncture for today's purposes. Because no one can point me to where that specific language was presented in their motion for issue preclusion or the reply for issue preclusion. I understand you raised it in your opposition, but I do not view that something that's not in the jury instructions that were presented to me and in the verdict form presented to me as the basis for issue preclusion would be before the court. I understand what you are saying. I understand your question, but the court's ruling is the court's ruling. I do not find that what you're asking is within the scope of what was sought by plaintiff's counsel, so I do not see this before me today. And I'm going to leave it at that, and I'm going to move on.
That Milwaukee is liable on the claim of breach of implied warranty.
Counsel, I understand you want to continue this. The court has made its ruling. I've given you 3 or 4, right, to say it, but it's not time to reopen it because then I go back to plaintiff's counsel. They get to re-argue back and forth. The court made its ruling based on what was presented to this court, right, not something that was not presented to the court. So that's the court's ruling. It is so ordered. Okay, I've taken care of the motion for partial summary judgment. I'm now going to move forward. I've got 2 choices. Realistically, I can ask you to come back at 1. Is probably the safer thing to do because I don't think we can. If you think we can get through your jury questionnaires in 10 minutes, that's fine. If you don't think,
I don't think so, Your Honor.
well, since you can get witnesses in less than 4 minutes, I thought maybe I'd try it, but
I could do it.
yeah, okay. Anyway, see you back at 1 o'clock, okay? Go ahead, counsel.
Briefly for Water of Tennessee.
Oh, you're right. I'm sorry. I said I was going to get back to you, and I did not. My apologies. We got sidetracked with Milwaukee. My apologies. With regards to Real Water of Tennessee, in light of the court's ruling, really isn't it moot as far as Real Water of Tennessee because of the assertions made in the court's ruling? Sorry, Mr. Schumacher, on behalf of Real Water of Tennessee, is what he meant to say. I would view it as moot because in your third-party claim, it would have to come from certain determinations in the first-party claim. So does that take care of your concern, counsel? And my apologies, I did mean to go back to that, and we got a little sidetracked with.
Thank you, Your Honor. It does.
Okay, thank you so very much. Okay, so now we'll see you back at 1 o'clock to go over jury questionnaires. Yeah. Okay, we're recalling. We said 1:15, folks. It's 1:15, so whoever we've got, we're moving forward. Continuation of pages 2 through 29, case 831543, Myles Hunwardsen et al. Versus Vinity Lifestyles DBA Real Water et al. I'm not going to require appearances. Again, I'm going to treat it as the same appearances from this morning unless we have anyone new joining us who wants to make an appearance. Is there anyone new? I know there's no one new in court. Is there anyone new remotely? Nope. Okay. So, friendly reminder here in court that if you're going to be talking, we need you near a microphone. So, if anyone's going to be talking, what I was going to do is we were going to do discuss jury questionnaires first conceptually. Did you? Okay, thank you so much. Appreciate it. Jury questionnaires conceptually, and then some of the motion stuff dates. So, but before we get to that, you all had told this court 3 weeks. So we're just doing a date check here. So 3 weeks, right? So it was supposed to be from the 16th, 3 weeks, which gets you to, well, February 2nd, possibly February 5th, since we're starting on a Tuesday versus a Monday. And the reason why the court's saying that is the time you all allocated for everything. So that's the time we are, kept on saying we're getting it done in 3 weeks. Most recently, the last hearing. Okay, so the reason why the court's saying that is if for some reason people are thinking this case is going to go any longer, then we are going to need to be dark for 3 days. And we just need to make sure to put those on the jury questionnaires. The 3 days are February 8th, 9th, and 12th. Okay, which shouldn't impact, given your current schedules that you all told me. But if somebody's thinking it's going to be longer, we need to be dark those days. So we need to figure out, is there something that we should be doing with regards to the jury questionnaires to take that into account? Or is that not an issue?
Your Honor, Eric Pepperman for plaintiffs. I would say we indicate 3 to 4 weeks with these dates being dark just in case, rather be over-inclusive. Hopefully we can get it done in 3 weeks and it won't make a difference, but if it does, at least the potential jurors.
That sounds like a practical. Just FYI, there's somebody, does everyone remotely have are they off? Okay, thank you. Go ahead, counsel.
Chad Fears for Hannah. I'm still getting my arms around the case, but I agree with Mr. Pepperman. That sounds like a reasonable suggestion with the jury questionnaire, having those dark dates and 3 to 4 weeks.
Okay, anybody else want to be heard? Anyone disagree? Yeah, I figure we start with the easy thing that everyone would agree with first, right? Okay. Right? I give everyone a chance to speak if they wanted to. I've got pretty much everyone here in court other than I have remotely. Terrible Herbst. Okay. So that's what I do. So I presume as we're going through things, people are taking notes, right? So that you all can get taken care of what you need to get taken care of. Okay. Checked with jury services today. Just FYI, things are running smoothly. The things went out. Right. So remember, you did get everyone got the email, right, from my JEA with the dates and everything. Okay. So jury services already starting to get, no surprise, people calling, right, with can't serve, all sorts of things. They're getting those taken care of. Remember, jury services is doing the mandatory exemptions and excusals. They're flowing through, getting taken care of that. There's no more insights in that regard. I was anticipating that might be a question, but so far, they're not getting a high number of one way or another or a low number of nobody calling yet. They went out recently, so they're getting what they're anticipating and it's moving along smoothly. Is this what the court was informed of earlier today. Okay. With regards to jury questionnaires, as you know, one of the goals of jury questionnaires, and the reason why courts do them, is because it's supposed to reduce the time for voir dire. I am fully appreciated sophisticated counsel, and particularly counsel who like to ask a lot of questions. So for those of you who've done this department before, know that I'm going to ask you for a ballpark of what is your voir dire timing, right? Because I appreciate that everyone may want to go on for days and days and days, or maybe not, but we need to make sure that it's an efficient use of time in light of the fact that you all are requesting, regardless of which version or modified version of these jury questionnaires, over 30 pages, right? And so we've got to be respectful of the members of our community's time who are serving as potential jurors. So please do not way overestimate. Please give me realistic ballparks, okay? Realizing that no one can anticipate that some people may wish to answer questions longer. There may be some more follow-up, but as most realistic as you can, because that's part of how we're trying to get scheduled. Because remember, we're also going to be scheduling other cases, and so we can't just eliminate taking care of all the rest of the cases on our docket, which some of your other cases of the attorneys that are here. So we start evaluating that as well. Counsels for plaintiffs, should I start with you?
That's fine, Your Honor. Teddy Parker on behalf of the plaintiffs, Your Honor. Typically, I take about 2.5 days to properly.
Combination?
Because
you only have one.
The last trial, Your Honor, I did it for all plaintiffs.
Okay, so just to let you know, I find it easier to say hours because sometimes I had one person come back to me a few years ago that when they said days, they were really meaning 24-hour days. So you can.
Not me.
It was not you. It was not anybody who's associated with this case. But you can appreciate. Since that, I now go hours because hours is 60-minute hours, not lawyer hours, and that way we just have a more clarity. So when you say, are you talking 15 to 20 hours, or what do you counsel?
Typically, Your Honor, if you're giving us roughly 7 hours a day, I'm looking at 2.5 days, so 14, 18 and a half hours, Your Honor.
Okay. Real Water of Tennessee. And I appreciate many people think that they may not need to be in this case, but since I've not heard any motions, I have no position, but I just want you to feel like you're always last, so I'm asking you next.
Well, I appreciate that, Your Honor. I'm going to be in line with.
You're going to have to.
Do you want me to go to somebody else first? I can come back to you.
You just need to find a microphone. Why don't you sit right here, Jim?
Thank you. Jim Cavanaugh for Real Water of Tennessee, LLC. We typically would align with Mr. Odou's clients in terms of jury issues, Your Honor. So I would like to defer to his estimates.
Okay, so do you anticipate that you're going to want additional time other than what Affinity Lifestyle DBA Real Water wants?
I would anticipate that if the third party matters are tried with the main action, and I would anticipate a half a day, 4 hours.
Real Water.
Thank you, Your Honor. Joel Odou on behalf of Real Water Inc., AffinityLifestyles.com Inc., and Real Water Gold Coast. Approximately 90 minutes to 2 hours.
Okay. Hannah.
Your Honor, I think it would be somewhere between 7 and 12 hours.
You understand that there's no way you're getting 7 to 12 hours, right? I mean, you realize this is getting you, do the math, folks. You're getting a week and a half of trial time or less. Okay, 7, come on, folks,
Your Honor,
everyone be realistic.
just 7 hours then.
I mean,
What in this chat fears for Hannah, I'm just going with my prior time that we've tried a case against Mr. Kemp and Mr. Parker. It was a little different. They, I think, took 2.5 weeks, and I know you're not going to allow that. And so we took like 2.5 days after that. So that's what I'm saying. Given Mr. Parker's saying 18 and a half hours, I would say 7 hours for us.
I mean, you can appreciate trial of 3 weeks. Not going to be 2.5 weeks of voir dire with a 30-page questionnaire. If now you all want to try this without questionnaires, maybe there's a different concept going on here, but I understand questionnaires is the most efficient, effective thing, and you all want it, so I have to balance, right? Longer the questionnaire, the more things extensive, really goes to less topics, and I appreciate that's the case law version. I appreciate that sometimes attorneys might have a different perspective. Been there, done that. But anyway, Mr. Cavanaugh, you're standing up. I think you're about to reduce your
Jim
time.
Cavanaugh for Real Water, Tennessee. I understood comments just a couple of minutes ago. Mr. Pepperman suggested this may be prudent to allocate 4 weeks with a couple of 3 days that you've categorized as dark to be included, I guess, within the 4 weeks. So the outer limits of this, I thought, were 4 weeks, not 3. I would suggest, based on Hannah's agreement, with a 4-week outer part, because we're already talking about cutting it down to under 3 weeks. And I thought just a minute ago we had all agreed it was likely to be prudent to allocate 4 weeks for the trial, including jury selection. Did I misunderstand? Maybe Mr. Pepperman and
Where I really was going is, your 3 weeks got you to February 5th, realizing that still gave a cushion of 2 days, but knowing that things happen, I wanted to make sure you all were aware that we needed to be dark. Because remember, things got planned before this case got moved at you all's request, right? So there's a lot of different moving targets the court's anticipating, but even a 4-week trial includes voir dire. So realistically, that's why this court's saying how much true trial time. And even in 4 weeks, you're not going to spend half your time in voir dire when you have 2 weeks. Anybody think you can get this case tried in less than 2 weeks because you want to spend 2 weeks in voir dire? That would get you your 4 weeks. So I'm hearing what you're saying, but we need to balance that. And remember, you all are asking for a 30-plus page questionnaire.
looking at these numbers that the folks have given you so far, I thought we were about 3 days into 1 week for voir dire, and still counting. I was just trying to make sure we're prudent and have enough time.
Remember the rules now. This court's, of course, going to allow voir dire, but anybody wants to take a quick little gander at the rules, right? On the limited aspect of voir dire, I'm trying to balance everyone's needs, but I'm trying to get you your trial time, right? Because you also are set, aren't you still set for trial February? So remember, this was set, and then you all were set in Judge Alf February 4th, February 6th, right after this. Has that been moved?
Yes, Your Honor. The next trial after this is the Cava trial, which is currently set on April. We have a pending motion to consolidate Cava into the Wren case because those cases we believe are substantially similar in a lot of respects. But pending that issue, right now, Cava is the next trial set to be scheduled in this department.
Right, I was asking this department. I had understood, you all had told me before that you had a couple of cases set in front of Judge Alf the first week in February.
That case was moved to May after the Cava case.
Okay, so it's Department 31, Department 31. I was trying to accommodate other departments as well. I thought you had some conflicts with timing, but you're saying that no longer is the case. It's this department and this department are the next two cases up, correct?
Correct, Your Honor.
Subject to your consolidation motion, which may put it somewhere else. And that's not before me because I'm not the lowball number on that one.
Correct.
That's Judge Alf. Right? Yeah, Judge
Yes,
Alf
sir.
should be for Wren because that's the lowest. Wren is the lowest of the numbers overall. If my recollection is correct.
Correct.
Okay. That's May. Okay. Milwaukee, would you like to give a time estimate, please?
Yes, Your Honor. The last trial, we took 90 minutes to 2 hours.
Okay. Okay, I'll take a look at these and we'll figure it out rather than doing it right now. Okay. So let's get to your juror questionnaires.
Did you ask Terrible Herbst?
Oh, my apologies. Thank you so much. See, with you not being here in person, it makes it a little bit harder to have all these blue boxes, particularly since the court's specific audio-visual appearance, no just straight, right? So
Good afternoon, Judge Jan Tomasik for Terrible Herbst. We request 3 to 4 hours for voir dire.
Thank you.
Thank you,
Yeah.
Judge.
Thank you. When people aren't audio visually, I assume they were just observing because. Okay. Mute, please. Now, thank you. If we're done with that part. Okay. So I've got 3 sets of questionnaires. So what I have plaintiffs, and then I have a red line set from Hannah Instruments, and a red line set from ETT1, DBA Terrible Herbst. Those are the only 3 versions this court's aware of receiving by the deadline. Does anyone think that they sent something else that I don't know about yet? Okay. So I think the easiest way, realistically, to go through it is to go to the first one that somebody has taken out of plaintiffs.